See, this is ridiculous, this, right? So, in the 2004 standing orders for 155, in the case of a petition presented under standing order number 153, presentation of petitions and complaining of some present personal grievance for which there may be an urgent necessity for providing an immediate remedy, the matter contained in such petitions may be brought into discussion on the presentation of the proceedings under this order may be presented with, though opposed, until any hour. Well, it says though opposed. Well, if the Speaker opposes it, that's the thing. They reckon in 1977 they changed the rules so that it's not presented at the bar, but it was never petition for grievance of privilege was never ordered to lie on the table, and it never went to the committee, right? But it could be read out because it falls under a personal grievance which needs an urgent remedy, right? But it says, although opposed. Well, they're saying after 1977 that you had to write a letter to the Speaker and he had to decide whether or not it could be heard or not. Well, that means that he's opposing it. If he doesn't allow it to be received, he's opposing it himself. But it says it may be given attention immediately, even if opposed. Well, they're saying that. Well, if the Speaker opposes it, this is the thing, right? And this is what John Tinker's talking about. But it says presented under the first rule, which is by a member, though. But apparently, it doesn't have to be presented by a member because if it's a judicial matter, you see why I raised that model for the Court of Aldermen, because you have the Court of Aldermen and then you have the Court of Common Council, which is the full council. And under the London Corporation rules, you can only give petitions into members of the council if you obviously live in the London area, right? But you might have a matter with the court that you're not from that area, right? And then you don't have a councillor. And you might be answering a fine or something like that. Well, if you're getting prosecuted by a court, but it's not a MP casework business for a local area or constituency, that's what I'm saying. Is Parliament to be treated like without the MPs, sort of? Is that why you don't need them to sign it, similarly to when you have the Court of Aldermen, in contrast to the Court of Common Council with full council, and the difference between standing orders for the Court of Common Council and the standing orders for the Court of Aldermen. It's a sort of similar situation. But nevertheless, it doesn't say anything in these rules about writing a letter to the Speaker, I don't find. I mean, these are orders that stand. These are orders that stand and carry over, although, sorry, that was after 1977, wasn't it? We haven't got to 1977 yet, but nevertheless, there doesn't even seem to be any powers in here. They don't seem to have created the petitions committee in this. Now, these are the 1912 standing orders, and I don't really find anything about privilege actually in this petition section. There isn't an actual separate section for motions of privilege, and there doesn't seem to be a separate section for privileges committee. There's just public petitions, and it mentions privilege in with the public petitions, so that gives a very clear association and direct association in the 1912 standing orders with anything to do with privileges seems to be grouped in with the petitions. So it seems like very linked. It seems very connected in a historical sense with the standing orders. Every member offering to present a petition to the House, not being a petition for a private bill or relating to private bill before this House, shall confine himself to the statement of parties from whom it comes, the number of signatures attached to it, and the material allegations contained. Right. If it was a member, and he himself is complaining about privileges of himself, that you're not allowed to present a petition from yourself, if you remember, right? So you've got to get one of your colleagues to present it anyway, right? You would have to get one of your other members to advocate it for you, I would have thought, right? I don't know if it says that a member not, in these standing orders, it doesn't know if it says that a member may not present a petition from himself. That isn't in standing orders. That's going to be Erskine May, but where did that come from, though, if it's not in standing orders? Which is an interesting thing to ask, you know, because Erskine May was only written in 1844, and before that, there's a load more rules apparently pre-existing in the 1832 report. And I don't know if a resolution is not put into standing orders, apparently it doesn't stand anymore. How about when they change standing orders and they don't exist anymore, but it ends up not being a rule anymore? You know, surely standing orders are only rules which stand. A research petition not containing a matter of breach of privilege of this House, and which, according to the rules or usual practice of this House, can be received, right, shall be brought to the table by the direction of the Speaker, and shall not allow any debate on it. So if it is a petition of grievance of privilege, then it can have debate on it then, and it won't be ordered to lie on the table, right? Because it will fall under... In the case of such a petition complaining of some present personal grievance of which there may be urgent necessity, well, if there's a privilege issue, it will be urgent if it's a member or the public, surely, for which there may be an urgent necessity for providing immediate remedy. The matter contained in any petition may be brought into discussion on the presentation thereof, right? Now, it doesn't actually say anything at all about it being opposed, right? Now, this is not, this is before 1977, right? But it doesn't say anything about it being opposed. It says in the 2004 standing orders about being opposed, but this is the thing. Apparently, this is the thing. If you're not allowed to present, he never was ordered to lie on the table and go to the petitions committee anyway, right? Well, they're saying that you got right to the Speaker first, right? But this is the thing. Once the Speaker opposes it, it says that it can be heard regardless of whether opposed. So how can that rule stand with the Speaker? I don't know. I'm going to have to read this 1977 report thing, because I don't know if it actually did get implemented or not, or whether it was just a recommendation. But they definitely messed around with the book